Okay, so we're going to learn about Chapter 4 now. Chapter 4 is fair housing. This is the chapter about anti-discriminatory laws. We're going to learn all about we're going to learn about all different types of discrimination and laws that protect the consumers. It's called fair housing. So in this chapter, we're going to identify protections of the federal fair housing laws, including enforcement. We're going to describe the protections of New Jersey law against discrimination, including state regulations on rentals. We're going to discuss the implications of fair housing laws for both brokers and their salespeople. So it all starts with having an equal opportunity in housing. These days, I don't know what's up with the younger generation. I know I sound like an old fart now, but I don't know what's up with this younger generation. They expect everything to be just given to them. All right. They are entitled. They have this entitlement air about them. Some of them do anyway. I'm not talking about all you guys, because of course you're here to do some hard work and earn it, right? You're not here to get stuff handed to you. So everybody has the right to equal opportunity here in this great country that we're about to celebrate our 250th anniversary that we made it here. Okay, there are some elements trying to tear it down and change it, and that just basically hate our country the way that it is. So they try to tear it down. This is the great experiment, the United States of America. Even foreigners that come here love it. They don't want to leave, right? Look, they're coming here for soccer matches now, and they're loving it. They love our air conditioning. They love our salad dressings. Right? They try to smuggle ranch dressing out of the country, for crying out loud. I had no idea that wasn't a thing in other parts of the world. Think about how good we have it. They're loving the size of the drinks that they get and the portions of the food they get here. uh, the supermarkets blow them away because they don't have things like that in Europe or other parts of the world. A lot of this stuff is unique. The things that we take for granted is what uh, the younger generation just does not understand, because you grew up without having any hardships, any true real hardships, in this country. You didn't have to deal with any wars or anything like that, probably in your lifetimes. Any hardships of waiting in line for food or anything like that. So because you got so spoiled and entitled, you don't think that you are. You think your hardship is the the connection for your iPhone not to connect to the satellite to get internet is disrupted once throughout the day for an hour. That kind of stuff, right? No, I'm not talking about all of you. I'm just talking about society in general these days, here in the United States. We're so damn spoiled. They talk about privilege, and this one's privileged and that one's privileged. You're all privileged. Okay. You just don't know it. Okay. So in this country, we have an equal opportunity to housing, not an equal right to the outcome. I mean, I'd love to own a big mansion. I just can't afford it. What about you? If you work hard, you start earning more money, maybe you can be able to buy that. You have the same opportunity as anybody else does if you become successful like that, that you could own such things. Okay. And that crosses the boundaries of race and gender and all of that. We all have the same opportunity. It's what you do with that opportunity that matters. Okay. You don't have a right to the same outcome. And right now, we're seeing a lot of shifts in politics. You're hearing on the news every day about democratic socialists. They're pushing socialism. If anybody ever experienced socialism, you would say they are friggin' idiots. Socialism has never worked anywhere on this planet throughout history ever. Okay. And we're seeing a segment of people that are actually pushing this stuff. So The federal, state, local laws about human rights and fair housing affect rentals and sales at every phase of a real estate transaction from listing to close. And failure to comply with fair housing practices are not only grounds for the loss of your license, but it's also an unlawful act. And with that there, I threw a little note down at the bottom for you, and it applies to a lot of stuff, not just these anti-discriminatory laws. It applies to a lot of things, whether it's building codes or whatever it is, uh, deed restrictions, what have you. When two laws or two rules cover the same topic, which one do you follow? You follow the more restrictive rule. The most restrictive rule will always prevail. Okay? So if you have one law that says you can't do this and another one that says you can do that, you follow the one that says you can't, because there's two laws covering the same thing. You got to follow the more restrictive rule. Okay? So why do we have fair housing laws? Well, so everyone can have equal rights and opportunity to have a place to live, whether you're owning it or renting it. We all have a right to have a place to live, and to be able to own personal property. I think I mentioned to you guys once before, I'll say it again. There are only two types of property on this planet. They are personal property or real property. When I say real property, we're talking about real estate, okay? Meaning ownership of real estate. So you either own real estate or it's personal property. It's one or the other, okay? So violating these laws is a criminal act, these equal housing opportunity laws. Let's start off with the oldest one first. The Civil Rights Act of 1866. What significant thing happened back in the 1800s pertaining to people's civil rights? Our leap towards fairness and more equality for everybody. Who was the president way back then? Anybody guess? Come on, this guy, he's known for being tall, having a big hat, and freeing the slaves.
Lincoln.
There you go, Lincoln, the Emancipation Proclamation, right? Now, did that put an end to all discrimination? No, of course not. These things take time. We're humans. When people are stuck in their ways, it takes time for things to change and progress to happen. We're still experiencing changes. You know, there's always going to be discrimination and biases of some sort. But this country has gone leaps and bounds beyond any other with all of your freedoms and rights and the how we strived for equality amongst everybody. So the civil rights, you're always going to get someone that's going to bitch and complain about these things. But look, try to compare us on anything to other countries, and we far exceed. That's why people love coming here from all over the world. They love it, you know, and I can't blame them. And people from other parts of the world appreciate it here in the United States, what they actually get, than the spoiled ones that were born here and do not appreciate it. It's amazing. It amazes me how much foreigners appreciate it more than those who are born entitled. Okay? So the Civil Rights Act of 1866. The efforts of the federal government to guarantee equal housing opportunities to all U.S. citizens began with the passage of the Civil Rights Act of 1866. This law was an outgrowth of the 14th Amendment of the United States Constitution that prohibits any type of discrimination based on race or color. So what are the protected classes on this law? The Civil Rights Act of 1866? It deals with race, right? Race and color. It says that all citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof, to inherit, purchase, lease, sell, hold, and convey real and personal property. Okay, so this law covers what protected classes? Race and color. And what kind of property is covered under this law? All property.
Real and personal.
Real and personal, and there's only two kinds of property on this planet, real or personal. So it covers everything, all kinds of property. Okay. So because of its reference to white citizens, the law has been widely interpreted as to prohibit discrimination based on race and color. So you'll need to know that for exams. You'll get questions on exams about that. What are the protected classes for the Civil Rights Act of 1866? Just think back, 1866, way back then, Lincoln freed the slaves. Okay, even though there were slaves that were white as well, there's slaves of all different backgrounds and from all different colors. But more commonly, we think of Black people being slaves back then. So you're going to remember race and color. And when we think of the protected classes, well, what did Lincoln do? He said that everybody has an opportunity to own property, whether it's real or personal. Personal was addressing arguments that the slaves didn't even own the clothes on their backs that was given to them by their slave masters and all, right? So Lincoln said, no, 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 no. You have the right to own your own clothes that you wear that's on your own back. You have a right to own real estate as well, okay? So this covers all property. And the protected classes are race and color. Even though years later they added two more protected classes to this, but we'll hold off on that for now. Let's just continue with the reading here. In 1968, there was a court decision for a lawsuit where Jones versus the Alfred H. Mayer Company. Jones was an African American, and he thought that the Alfred H. Mayer Company was discriminating against him based on his race. But the Alfred H. Mayer Company said, well, there's another law, the Civil Rights Act of 1966, and that law has some exceptions to it, and it covers a lot more protected classes, and it has some exceptions to it. So the Alfred H. Mayer Company was saying, oh, because this law has some exceptions to it, we are allowed to discriminate based on this and that and the other thing. And the Supreme Court ultimately held that when two laws cover the same topic, you got to follow the more restrictive rule. And the Civil Rights Act from the 1800s, from 1866, says that when it comes to race or color, there are no exceptions to the law. You cannot discriminate ever on the basis of race or color. So that Supreme Court decision in 1968 changed a lot. It solidified the rules that were already there that may have been misinterpreted by others. Okay, so let's highlight there are no exceptions when race or color is involved. So you're just highlighting these words. Civil Rights Act of 1866 prohibits any type of discrimination based on race and color. Real and personal property are covered by this law, and there are no exceptions when race or color is involved. Boom. Everything you need to know. Almost. So I got a slide just for this. Civil Rights Act of 1866, part of the 14th Amendment of the United States Constitution, grants equal rights to all citizens for ownership of both real and personal property. That's all property. And when it comes to race, there are no exceptions to the federal law. All types of property are covered by this law. All real estate, residential or commercial, including open, unimproved land. Personal property, like the clothes on your back and your personal belongings. The protected classes are race and color. However, in 1987, they amended the Civil Rights Act of 1866 to also include ethnicity and religious groups, ethnic groups and religious groups. When it comes to the real estate, it's enforced, the rules are enforced by HUD, the Department of Housing and Urban Development. And violations under the Civil Rights Act of 1866 have to be heard in federal court. And the statute of limitations is determined by state law. And federal court has no monetary caps on awards and settlements at all. So let's highlight on page 68. Well, first of all, let's underline the word in the title where it says the Federal Fair Housing Act of 1968. Let's underline the word housing. It's got the word housing in it. So what do you think kind of property is covered under this law?
Well, this housing.
Federal Fair Housing Act. What kind of property is covered by it?
Housing.
Okay, well, housing is real estate, and houses are residential, not commercial. So you could come to that deduction just by thinking about what is a house. Is a house is real estate. Is a house residential or commercial? It's residential. So the Federal Fair Housing Act of 1968 covers what type of property? Residential real estate. So the Federal Fair Housing Act of 1968 is contained in Title 8 of the Civil Rights Act of 1968. Oh my God, we got to learn about these three laws now? No, it's all one law. Take a breath. Let me explain this. Let me break it down for you. In 1968, there was a whole big civil rights movement that covered all kinds of things. It did away with segregation in our schools, even though you're seeing some of the younger people in, I guess, the last 6 to 10 years in colleges. They're like, we want our safe spaces to be separate from other people of other races. Are you kidding me? Your ancestors were fighting against segregation and you're fighting for it? You're kind of losing the concept behind it there. So the Civil Rights Act of 1968 covered all kinds of things like segregation, where if you were a black person and you wanted to use the bathroom, you had to use the black bathroom, or actually they called it the coloreds bathroom. Or if you wanted to use a water fountain, you couldn't use the white people's water fountain. You had to use the colored water fountain. They were labeled like that. They had signs up. You could be arrested for it if you didn't. You were segregated. You could be jailed for not sitting in the right place, right? So the Federal Fair Housing Act of 1968 is contained in Title 8 of the Civil Rights Act of 1968. 1968 was a whole movement of laws covering many different topics. Segregated schools and bathrooms and where you could sit on a bus maybe, or all kinds of stuff like that, right? Is covered under that law. Well, Title 8 is a section within that whole body of laws that were civil rights laws that were passed in 1968. And Title 8 also goes by a name. It was given a name called the Federal Fair Housing Act of 1968. So Title 8 is very specific. It deals with real estate, residential real estate. So what is it called? The Federal Fair Housing Act of 1968 is what we call Title 8, is what we refer to Title 8 as, okay? I hope that clarifies things a little bit. These are not two separate laws. Title 8 and the Federal Civil Rights Act of 1968 is the same thing. They're just a section within the whole body of laws that were passed under the Civil Rights Act of 1968, okay? Now, this prohibits discrimination on the basis of more protected classes. Race, there's 7 protected classes covered by federal law. Race, color, religion, or national origin, including the religion of your ancestors, and sex when selling or leasing residential property. Okay, I know that doesn't cover all of the protected classes just yet under federal law, but that's because in 1968, these were only the 5 protected classes. Actually, 1968, sex wasn't even there yet. That was added later. So there are 7 protected classes under the law. These are a couple of them as of 1968 when it was passed. And when selling or leasing residential property, the law impacts direct providers of housing, including landlords and real estate companies, as well as municipalities, lending institutions, and homeowners insurance companies. They cannot discriminate against any of these protected classes based on, well, the protected class. So here is more information, probably everything you need to know about the Federal Fair Housing Act of 1968, or not everything, but most of it. The Civil Rights Act, and I reworded it so you could better understand it. The Civil Rights Act of 1968 has a section dedicated to housing called Title VIII, also known as the Federal Fair Housing Act of 1968. And it does have some exceptions. Now, the type of property covered under this law is residential property, whether it's for sale or lease. It includes vacant land used for residential purposes. The protected classes under this law are race, color, religion, or national origin. In 1974, sex was added as a protected class, and then in 1988, they added let me see, 1974, sex was added, and people with disabilities, including AIDS, as well as familial status, was added as a protected class. So we have race, color, religion, national origin, sex, people with disabilities, and familial status. Those are your 7 protected classes under federal law. Alcoholics and persons in drug treatment programs are considered to be a protected class. However, we got laws now, people sticking up for all the drug addicts and stuff, saying, well, you can't ask them if they're in a treatment program, because if they're not in a treatment program, they're not a protected class because they still pose a harm to the public, themselves, and others. However, alcoholics and persons in treatment programs are a protected class. Now, current drug abusers and people who pose a threat to the health and safety of others are not a protected class. Who does the enforcement of the Federal Fair Housing Act? Once again, that's HUD. HUD is the Department of Housing and Urban Development. Under the federal law, you have 1 year to file a complaint to be heard in front of an administrative judge within HUD. HUD has their own courts that all they listen to is discrimination cases that come before them. And you have 1 year to file a complaint and have it heard in front of a HUD's administrative judge. Or 2 years if you want to make a federal case out of it, okay? So if you're past that statute of limitations for 1 year, you could have it heard in federal court for up to 2 years. And if it's heard in federal court, there are no monetary caps on awards and settlements. Whereas the administrative judges within HUD, there are maximums for the awards that they could award for those settlements. Okay. Everybody got a screenshot of this that wanted one? Okie-dokie.
Yes.
All right, so let's look at the book now. Here's what it says in the book. Let's do the highlights. 1, 2, 3, 4, 5 bullet points down, page 68. Let's highlight the protected classes and also add sex there because they left that one out. Now, these definitions of these words have changed a lot too. You get a lot of people, they get lazy, they don't want to change the laws. So what they'll do is they'll change the definitions of words So basically all the laws that are already written that use those words have to change too. Getting into that too much though. Anyway, race, color, religion, national origin, disability, and familial status, as well as sex. When it came to sex as a protected class, that has been expanded on a lot over the years to include other things other than male and female. That's what sex is. It wasn't until I think the almost the mid 70s they added another word called gender. Okay, gender is basically a psychological condition. Okay, I don't know why. At some point, they changed the word sex on like a hospital intake forms and such like that. They used to ask, "What sex are you?" Okay, male or female. Now they ask gender. Gender is a psychological thing, so you could say, I'm a furry. I'm a all this other nonsense that came about now. So it gets a little confusing. But that's not covered under federal law. Under state law, it is. Now, I want you to write blockbusting and panic peddling at the end of that line, too. Right? And then on the next line at the end of it, the next bullet point, I want you to write the word redlining. That's one word. Redlining is one word. Okay, so I'm going to go over this list right now with you. However, I'm going to go over it on the next slide where I typed it in because I modified these bullet points a little bit to make more sense. And some I just changed a word or two. You guys can follow along in the book and see what I changed, okay, as I read through. So here we go. This is the same slide. It's just my typed up wording of it that changed, okay? So the Civil Rights Act covers dwellings and apartments as well as vacant land acquired for the construction of residential buildings, and it prohibits the following discriminatory acts. Refusing to sell, rent, or negotiate with any person or otherwise make a dwelling unavailable to any person as a means of discrimination. Changing terms, conditions, or services for different individuals as a means of discrimination. Practicing discrimination through any statements or advertisements that restrict the sale or rental of residential property. Representing to any person as a means of discrimination that a dwelling is not available for sale or rent when in fact it is. Making a profit by inducing owners of housing to sell or rent because of the prospective entry of persons of a protected class into the neighborhood. That one is changed a lot more than what the book is. It gives a better explanation. Particularly based on these protected classes: race, color, religion, national origin, sex, disability, or familial status. Those are the 7 protected classes. And this is called blockbusting or panic peddling. You need to know those 2 terms, blockbusting and panic peddling. This is when somebody plays on someone's fears of a protected class by saying, these people are moving into your neighborhood. They're going to destroy the property values. The neighborhood's going to go downhill. They come up with some sort of a story to induce panic, to get you to bust up the block and sell your property. And of course, they'll step in as the hero to try to save you and buy your property from you. But of course, it's going to be at a reduced price, because those people are moving into the neighborhood and they're going to destroy the value and all. Yeah, you guys see the whole scheme that's going on here? This actually was a big thing in, where the hell was it? Baltimore. I seen a documentary on this once. In Baltimore in the 60s, there was these group of investors. They were knocking on people's doors, going around the neighborhoods. After the whole Civil Rights Act movement and stuff, they started knocking on people's doors in the neighborhood saying, listen, You got all these black people and Hispanics that are going to be moving in your neighborhoods. They're going to become run down. They're going to drive down your property values. Crimes are going to go up. But I could be your hero and buy that property from you. Of course, I can't pay top dollar because property values are going to go down and all, you know. So, but I could give you the premium price that you're going to get on it right now. And then they even paid a young black girl to push a stroller down the street while they were talking to those people. And they were like, see, look, they're taking over already. This documentary was actually showing some of the practices that these people were nothing but opportunists. Okay, they were trying to scam people out of their properties to get them to sell their property at a marked down price by playing on their fears by building some kind of story to try to scare them into selling. Now, it could be about anything. It could back then it was mostly about race and color. But you know, today you could still see some of this. It's not really so much about race and color anymore, but you could see it maybe about religion. You know, oh, look, all the Jews are taking over, or look at the Muslims moving into the area, you know, or you guys understand what I'm talking about here. You guys see this stuff. But it could also be about disability. Look at disability. Do you hear what they're putting in next door with that big house next door? What they're doing? They're gonna turn that into a halfway house for recovering drug addicts. Oh, remember, drug users that are in recovery are considered a protected class under the disability protected class. So they play on this fears. Oh, you're gonna have all these drug addicts around. They're gonna have needles all over the ground. You know, the neighborhood's gonna get dangerous having these people in. Okay. Once again, that's another way they could use this. Creating a story of selling panic peddling, to try to get you to bust up the block. Or familial status. You know, people with familial status is discrimination against people with families. Okay, people who have children under the age of 18. This also includes pregnant women. Okay, so they're all covered under the familial status. All right. Altering terms or conditions for home loans or insurance policy to any person who wishes to purchase or repair a dwelling or otherwise deny such a loan as a means of discrimination, even though they can afford it. That's called redlining. Yeah, that definition has changed a lot from what's in the book there. Yeah, I gave a little bit more of an explanation, even though it's only 3 lines. I modified it enough to make more sense than altering terms and conditions for a home loan to any person who wishes to purchase, repair a dwelling, or otherwise deny such a loan as a means of discrimination. See, I elaborated a little bit better there in that bullet point that you see on the slide. It says, altering terms or conditions for a home loan or insurance policy to any person who wishes to purchase or repair a dwelling or otherwise deny such a loan as a means of discrimination, even though they can afford it. That's called redlining. So redlining deals with the money, refusing to give people home loans or homeowners insurance, things of that nature. So think of red ink, you know. Think of finances. When you're in the red ink, red is not good. So that they put a red line through your application. Now that's not where they get the term redlining from. I'll actually show you a short video that shows you where they actually got the term redlining from. But the term redlining, and you thinking of like your checkbook and putting using a red pen, that's not good, right? You're putting a red line through the application. Okay, you're denying it. Okay, that's a good way to remember what it pertains to. Now, denying people membership or limiting their participation in any multiple listing service, real estate brokerage organization, or other facility related to the sale or rental of a dwelling as a means of discrimination. Yeah, that one I got to laugh at a little bit because, you know, I could join any of them. There are so many different realtors organizations now, right? It's not just NAR or your local realtors association. You also have other variants. You have the Hispanic Association. You have an African American Association. You have the Asian Association. You have Women's Council. By the way, me and my ex-wife actually helped bring the Women's Council to New Jersey. Even though we're nowhere on the charter, they kind of like wiped our names off of it as they took over. One particular brokerage took it over, used it as a means to recruit out of. But over the years, it has improved, and more brokerages from different brokers got involved, so that one particular brokerage isn't just putting all their agents in there as all the leadership positions anymore. So that's good. I'm glad that happened. But me and my ex, we gave up on that when they took it over like that. But look, I'm not a woman. I was a founding member of the Women's Council here in New Jersey. You know, I could be a member of any of them. You know, I'm not black. I'm not Hispanic. I am not Asian. But although I was invited to join the Asian Association, which is based in Edison, actually. Mei Ling created that one here in New Jersey from M3 Realty. Props out to her for that. And there's a lot of different associations, and I could join any of them. And if I was denied membership of any of them, because look at me, I am a straight white male. Okay. Then I got a lawsuit on my hands because that's discrimination under the federal law. Okay. All right. So the Federal Fair Housing Act has some exemptions to it, has some exceptions to it. So some exceptions to the Federal Fair Housing Act of 1968 include the following, but never on the basis of race or color. Why not? Because we know that lawsuit of Jones versus the Alfred H. Mayer Company said when two laws cover the same topic, the more restrictive rule prevails. Because the Civil Rights Act of 1866 says that when it comes to race or color, you could never discriminate. So even though this newer law has some exceptions to it and it covers race and color, we'll see why it has exceptions and what those exceptions are in a second. Right, they're right here on the slide. Yeah, some of them may make more sense than others, but you know the lawmakers put these in for a reason. But just remember that because this one has exceptions to it, it doesn't mean that you could discriminate against somebody because of their race or color, because it falls back on the Civil Rights Act of 1866, where when it comes to race or color, you could never discriminate. Okay, so that being said, let's look at some of these exceptions to the Federal Fair Housing Act of 1968. Once again, only dealing with residential real estate. The sale or rental of a single-family home is exempt when the home is owned by an individual who does not own more than 3 such homes at one time, and when A, a broker, salesperson, or agent's not used, and B, discriminatory advertising is not used. If the owner is not living in the dwelling at the time of the transaction or is not the most recent occupant, only one such sale by an individual is exempt from the law within any 24-month period. And the rental of rooms or units is exempt in an owner-occupied 1 to 4 family dwelling. Dwelling units owned by a religious organization, not a religious person, but a religious organization, may be restricted to people of the same religion if membership in that organization is not restricted on the basis of race, color, national origin, disability, or familial status. I say not an individual because you can't claim that, hey, I could discriminate because I only want people of my religion to buy my house. No, can't do that. But a religious organization that owns a property, they can. Now, a private club that's not open to the public may restrict the rental of its or occupancy of its lodgings that it owns to its members only, as long as the lodging are not operated commercially. Yeah, so those are the only exceptions to the Federal Fair Housing Act. of 1968. Now, in 1968, the Federal Fair Housing Act of 1968, 1988, mental or physical disabilities, including people with AIDS, COVID-19, or any other disability, mental diseases or defects or physical ones, are covered under the law now. 1988, they also added familial status as a protected class. That means you have family members under the age of 18, including adopted or foster children and pregnant women. In 1995, they amended the Civil Rights Act of 1968 to also include Housing for Older Persons Act, because that was passed in 1995, HOPA, which contains a limited exemption from the familial status prohibitions for housing for older persons. Okay, so if you got senior housing, can you have young children living there? No, they can be restricted from living there. A lot of these senior housing places, they could restrict it to like no children under the age of 16 or 17. It depends on that particular housing complex or building, what their rules are. But they do allow very limited exemptions based on age, because the old people don't want to have the young kids running and yelling and screaming and have their toys everywhere and running up and down the hallways and such, you know. So they allow this because the housing is meant to be strictly really for older people, 55 and older, or senior citizens, which is 62 and older. Now, in 1974, they passed a new law called the Federal Equal Credit Opportunity Act, ECOA. And the purpose of this law was to protect women. So the protected class was sex. Back then in the early 70s, there were a lot of sexists around, okay? The men were the ones that worked hard and brought home the income, and the little lady took care of the housekeeping and took care of the children in the home. Okay, yeah, I know it sounds kind of demeaning, but it's not necessarily demeaning. Some people love the housework and taking care of their children, and it is hard work and it is a job for them. But you had some people, maybe they're women, maybe they were single women, they were divorced women, and maybe they wanted to be able to buy a house or a car. And then you go out to buy a house or a car, and the person there that's supposed to be helping you is like, well, where's your husband at? Why don't you go home, little lady, and bring your husband out so the men can talk about the business and settle these issues. You know, I mean, today you're like, you're pulling back, and gasping. Oh my God, somebody actually says talk like that. Yeah, that was actually quite common. But this just shows you how over time things change and progress happens. So in the 1970s, there you had the whole women's lib movement, right? Where you had women, they wanted to have professional careers and such, and they started putting off having babies and all, which that creates different dilemmas for them. What do I want to do? A career? Do I want to have a child? Can I do both? That's on them. Either way, you cannot discriminate against the person. So the Federal Equal Credit Opportunity Act, ECOA, basically says if somebody is ever denied credit, you apply for a credit card, buy a house, buy a car, whatever it is. If you're ever denied credit, the creditor is required by law to send you an explanation in writing why you were denied. And the reason behind you getting that explanation in writing now is because of this law that was passed in the 70s to prevent discrimination against women. Now, in the book here, they add all the protected classes to it. That's because all the protected classes are covered by these laws, of course. But when it was originated, its primary goal was to protect women who were greatly discriminated against. So The discrimination against applicants because of their race, color, religion, national origin, sex, marital status, age, or the fact the applicant receives income from public assistance programs or exercised any right under the Consumer Credit Protection Act. Women thus had access to more housing opportunities. Oh, there you go. That last sentence really tells you what it's about. It was to protect women. Okay. Even though they ended up throwing in a bunch of the other protected classes in here. The last sentence really tells you what it's all about. It was to protect women that were discriminated against. But the law covers really everybody. All right. And alcoholics and persons in treatment programs are considered protected class under the disabilities protected class. So here's my slide that I wrote up about familial status with the explanation about exemptions for housing for older persons, HOPA. Senior housing is housing that is strictly for those 62 and older. However, these housing complexes or buildings have to post near all the entrances or in a common hallway or what have you, that the housing complex or building is meant to be housing for older persons. Same thing for 55 plus communities. If 80%, in order to be considered a 55 plus community, 80% of the units have to be occupied by at least one person that's 55 or older. So can you be under 55 and older and live in a 55 plus community? Sure can. As long as at least one person is 55 and older. Now, that person could be your parent, their adult child living there with them. Or maybe they're your spouse. Maybe you married somebody who's 55 and older and you're younger. You can live there. And if they ever pass away, you don't have to leave. You could stay there. You could remain living there because you own the unit now. It was left to you. And you were living there to begin with when they were there. They can't kick you out because you were there with somebody who was 55 and older. It's just that they now passed away. So if that happened, look, if 80% of the units are occupied by at least one person, so that doesn't mean that every unit has to have one person 55 and older. And that only situation, you can't move in there if you're not. However, if there's one person, you can't move in there if there's not at least one person that is 55 and older. However, if that person passes away, you could remain living there. That's how those people who do not have anyone there that's 55 and older may be living there still. And the housing facility or community posts that its policies are demonstrate that its intent is to be for housing for older persons 55 and older. All right. That's it for that. You guys did all those highlights and stuff of what it, wait, maybe you didn't, because we didn't get to it yet. Anyway, here's a question. I already asked you this, guys, and we already went over this kind of earlier, I think yesterday. Can a buyer younger than 55 and older purchase a property in a 55 plus community if they're going to rent it out to 55 plus tenants and the community allows rentals? Can each individual homeowners association determine the restriction on the age of the buyer? Well, I went to that New Jersey Realtors, the legal diary there, and asked the question. And they have lawsuit currently in progress. As of January 12th, 2024, that was a question. There were some municipalities that only wanted to allow 55 plus and senior communities can only be purchased by those that meet those age requirements. But then NAR got involved, or New Jersey Realtors got involved, and their attorneys got involved and pushed for challenging that. And I understand why, and I fully agree with why you would not want somebody who does not meet those age requirements to be purchasing, because it defeats the purpose of housing for older persons and to get those benefits if you got investors that are buying them and then marking up the cost to rent or sell them to seniors. Okay. But New Jersey Realtors is just in the business of promoting sales and rentals, so they fought against this. And here's actually the court document that shows what went down. It was actually a court case, New Jersey Realtors versus the Township of Berkeley. In July 2024, the court agreed with New Jersey Realtors and ruled that the age of the occupant, not the age of the owner, which matters, and that someone under the age of 55 or 62, as applicable, cannot be precluded from purchasing a home as long as they certify that the occupant will meet the community's age restriction requirements. So the court subsequently invalidated any local ordinances in towns that restrict buying the ability to purchase to those that meet those age requirements. Okay, so on page 69, next to this bullet point, we'll write senior housing. That's for those that are solely occupied by people 62 and older. That's senior housing. That's the bottom of page 69. And then we have a 55 plus community, which is the one that's occupied for 55 plus. If at least 80% of the units are occupied by at least one person 55 and older. Where'd everybody go? Why has everybody got their cameras off? By the way, let me throw out the after lunch attendance poll. This is a form. If you're going to get a listing and put it in the MLS and it's an age restricted community, you need to have this form filled out. It used to be when you got listings for sale and it's an age restricted community that only buyers that meet these age requirements can buy the units. Well, that no longer applies because of this recent lawsuit. So it used to be we put an age restriction in the MLS. And without having this form accompanying it, you are discriminating against the familial status protected class. If you don't certify that it is meant for housing for older people. Now you could only do that for rentals because apparently you can buy in these senior housing communities and be under 55 or 62, but you can't occupy. So you need to get this form filled out for the rentals anyway. Okay, service animals. Oh, we get to talk about the little fur babies. Okay, so Service Animals and Fair Housing Act, the FHA. That's different than the Federal Housing Administration. There's a law called Fair Housing Act. So the Federal Fair Housing Act makes it unlawful for housing providers. This is on page 70, by the way. Makes it unlawful for housing providers to refuse to make reasonable accommodations that a person with a disability may need in order to have an equal opportunity for to enjoy and use the dwelling. It says that assistance animals are not pets. They work. They perform tasks. They assist or provide therapeutic or emotional support for individuals with disabilities. Okay. So we'll have that all highlighted. let's see, consider the assistive animal as part of the person's disability. That's a good way to think about it. Okay. If you refuse their assistive animal, then you're discriminating against them because of their disability. Because you got to think of that animal as part of their disability. Okay. So there are two types of assistance animals. You have service animals, which are trained to perform a task, warn their owner that they have a seizure coming on because their blood sugar is running low, or they're seeing eye dogs, or whatever. They're trained to perform some sort of a task. And then you have those that don't require any training at all. Just simply having the animal helps suit the person's therapeutic mental disability. Like if somebody has PTSD or a nervous condition or something, they're emotional support animals. Okay? They're called ESAs, emotional support animals. Okay, so they provide the emotional support for the individual with the mental health or emotional disorders like depression, severe anxiety, or phobias, or PTSD. The landlord may not inquire as to the nature of the person's need, only the right to verify that the letter from the therapist is real and that the therapist is licensed, and confirms that the tenant has a need for an emotional support animal. So even if you have a no pets rule, a landlord has a no pets rule, they have to allow service animals and emotional support animals for housing. Okay. Now you need a prescription from your doctor, which is basically on a valid letterhead from your therapist or doctor. On the mental health professional's letterhead, along with their contact information, you need a phone number, email address, and the practice's address. HUD states that online certificates are not meaningful and should not be considered as verification. You got a lot of scam websites out there trying to sell people on the idea that they could get their pets certified as emotional support animals just by paying a fee, and we'll send you the vest that your dog can wear, and we'll even have the printed out little certificate that you could have, and the thing you could put in your wallet so you could prove to people that it is a service animal. I call bull. Okay, first of all, because it just says here that that's not legit, and second of all, there's nothing in the law that requires you to prove that it's a service animal, except for a landlord. You got to give them that letter from the therapist that they have a need for an emotional support animal, or from a regular doctor that they have a need for a service animal. Those websites are nonsense. Some of those websites you could go to, they look like they're so informative and so real with all the information that they have, with the laws printed out and everything. But on one of them, which a lot of them have this, but on one of them I went to, it actually said on there, they have a database where you could click to search the ID or license number for a service animal to confirm that they are in fact an emotional support or service animal. So anybody that questions you can go to their website and search the database, and it will prove for them that they're a service or emotional support animal. This apparently fools a lot of people to paying the $35 service fee, or $50 or $100 or $150, whatever they're charging you to get your pet certified as a service or emotional support animal, and then sell you a bunch of, the vests, the harness, all that other stuff. And they're basically just scamming you. Okay. You know why that's not true? There's no database where you could search to see if somebody has a disability or not. Remember, it says think of the animal as part of the disability. We have laws called HIPAA laws. You guys familiar with those? The HIPAA laws, the medical privacy laws, There's no public database that you could search and see if somebody's got a disability or a need for a service animal. That's nonsense. Okay. Now, the landlord can deny animals that pose a danger to other tenants or are disruptive or cause an undue financial burden to the landlord. Oh, tread with caution here, my friends. Additionally, neither service animals nor ESAs are permitted to roam off leash or throughout the property. They must be in their handler's control at all times. There is an exception for that, and that's only if having the leash could interfere with that service animal performing their duty in some way. Okay. Shops, businesses, and public buildings such as courts and libraries are legally required to admit service animals, even if their general policy is no dogs are allowed inside. They are not required any longer, they used to be, to accept emotional support animals. You know, I play pool on a couple of pool teams. We play in bar leagues, basically. So we're usually playing in bars. And I remember, this was a while ago, I remember playing in a couple of these places, and this group of young adults came in, and they came in with their pet. They had their pets with them everywhere they go. They came in with their little dog on their leash, and they're like running around, sniffing everybody throughout the room. They're inspecting the room all over the place. And I'm like, that's definitely not a service animal. Now, it could be an emotional support animal, but back then they allowed it. But they changed the rule because so many people were abusing these rules. They actually were not emotional support animals or service animals, and people just want to take their pets everywhere because they love their animals. So they're taking them into restaurants and bars and on the beach and all these places, and on airplanes. But that got a little bit too crazy. Okay, so under the federal fair housing law, it prevents discrimination against tenants in their homes. A landlord would be guilty of discrimination if they violate the tenant's right, providing what's known as a reasonable accommodation for the service animal, which can be assistance animals that perform tasks, or ESA, an emotional support animal, to soothe the person's mental condition when a tenant has provided a medical professional's prescription for one. By the way, the landlord could require a new one every year, because just like a prescription for drugs, people don't always have that disability or need for that emotional support or service animal. So they could require a new letter from your therapist. Most landlords, once they get to one, they don't. Under the FHA, disability is defined as a physical or mental impairment which significantly limits a person's major life activities. Even if the lease says no pets or restricts pets, landlords are required to make what's called a reasonable accommodation to allow pets who serve as assistance animals, which includes animals who provide emotional support, the ESAs. So assistance animals are in a different legal class than pets who are not assistance animals, which is why pet restrictions and fees are waived for them. They're animals that work, assist, or perform tasks or services that benefit a person with a disability or provide emotional support. There's no official certification or training for assistance animals, and they can't, because that would be too restrictive on the person with a disability. Or it could also an argument can be made that it discriminates against poor people. Maybe I could train my own assistance animal. Okay, so they don't have any specific required training. You know, you have to take a class with this certified institution or whatever to be, you have your pet certified as a service or assistance animal. Okay. Breed and weight restrictions also don't apply, which that could be kind of, that could be an issue in some areas. You know that there are some municipalities that actually have restrictions that don't allow you to own certain breeds of dogs because they have a reputation for being more violent and causing more damage and attacking people and such. So yeah, even a pit bull can be an assistance animal. But yeah, a lot of those animals, pit bulls, German shepherds, the Akitas, all kinds of animals like that. Yeah, they could be service animals too. Service animals are usually large dogs, though, the ones that are trained to perform a task. Because it would be very rare for you to see a very small service animal. Usually they're very large. Usually they're the large breed dogs, because service animals, if you ever see them work, they put their weight into it and lean against their owners. When they do that, they're trying to get their attention, to let them know, hey, you got an oncoming seizure. Sit down, and they kind of make sure that that Some of them, they will hit you with their snout, to try to get your attention. Hey, your blood sugar is running low. I'm going to show you a couple of videos examples of this. Now, what's the difference between service animals and assistance animals? Well, service animals, they're trained to perform a task. Assistance animals, they're there for the emotional support. Now, service animals can only be dogs. However, in certain circumstances, a miniature horse can be considered a service animal as well. The most common example is a guide dog, but you also have those that they could smell your blood sugar in your body and they know when a seizure is coming on, or you need to take your medication. They can alert you to that. Assistance animals, there's emotional support, but you could also have assistance animals that do things like this. You could have a cat or dog that detect and alert their companion of oncoming seizures, or alleviate a person's depression or anxiety, or reduces that person's stress-induced pain. Or they could have a bird that alerts their hard of hearing companion when somebody comes to the door. Oh, look at the butcher, look at the cute little doggy. Here, I'm going to show you this trained service animal notifying their owner of a medical emergency right here.
Oh, is it going low? Wait, let's see. Halfway down. Good boy.
Aren't these animals amazing? Oh, look how cute he is too. But these animals are amazing. How they could smell the blood in your body and know the sugar levels, and they could be trained that when the levels run low to alert you so that you could take your medicines or sugar. Look at that.
Oh, is it going low? Wait, let's see.
That's why they're bigger animals. You see how he had to get her attention, hitting her with his snout? Here, let's see another example of a service animal here. I should probably mute this. I think this one just has music. It doesn't have anybody talking or anything, but you could read the text here. Yeah, let me mute this so it doesn't get caught in our... when I upload it to YouTube, it doesn't flag the video as copyright violations or anything. So let me just mute it here and play. You see this girl here at the table here in the house, and there's her dog. He stops her because he senses something is wrong. He's trying to get her to sit down. He says, and I'll get your medicine for you. I'll be right back. He gets her medicine and then goes to the refrigerator, gets her a bottle of water to wash it down. Aw. These animals are amazing. Man's best friend. Dog is a man's best friend, right? There you go. There he goes for a reason. Look how they're there with you. They'll protect you too. All right. So How do you demonstrate your pet is a service animal? A letter from a therapist on their letterhead with their contact information. What do you do if your landlord refuses to accommodate a service animal? Well, you ask them for a reasonable accommodation, and if they still refuse, well, you could file a complaint against them for discriminating against you, just like you would for any other reason. So you could file that complaint with HUD, the Department of Urban Development, Housing and Urban Development, or you could file a complaint at any of the offices of the State Attorney General's office. Now, there are some exceptions under the Fair Housing Act for service animals. It says all types of housing, including public housing, are covered by the FHA, except rental dwellings with 3 units or less if the owner occupies one of the units. Single-family homes sold or rented by the owner without the use of a broker, because we can never discriminate. And housing owned by private clubs or religious organizations that restrict occupancy in housing units to their members. So, pet fees. Even though you could charge pet fees for having a pet. Service animals, including emotional support animals, they're technically not pets. And so the owners don't have to pay any additional fees for rent. The landlord, however, can charge a security deposit for damages that the animal may do. I mean, that's what security deposits are. Just do not call it pet security. You don't need to, because the maximum amount of security deposit that can be charged by law is 1.5 times the monthly rental fee. So if you're already charging a tenant 1.5 times the monthly rental fee, and they have a pet or a service animal, you cannot charge them any additional, because it doesn't matter how you label it. Pet security, it's something different. No, it's still security. And the maximum New Jersey law allows is 1.5 times the monthly rental figure. Okay, now they can charge additional rent for having a pet. However, if it's a service or emotional support animal, they cannot. Okay, and here I have a link to that legal diary on the NewJerseyRealtor.com that talks about those rental fees, and I basically printed it out here. And that's what it says. Any additional security deposit increase collected annually also shall not be greater than 10% of the current security deposits. Even regulates how much you could raise it. Okay, so I have a question here for you. Okay, here's a scenario. Pay attention, everybody. I'm going to ask you a question. How do fair housing laws apply in real life situations? Here's a real life example. John has been diagnosed with severe depression and is disabled as defined under the Fair Housing Act. His doctor prescribes John a dog to help alleviate some of his symptoms. John asks his landlord if he could have a dog as a reasonable accommodation for his disability. His landlord says yes, but tells John he needs to pay a $250 pet deposit and must provide proof that the animal's trained. Did John's landlord correctly handle John's request under the Fair Housing Act? And what if John wanted a cat or ferret instead? Well, what do you say? Did John's landlord handle this correctly?
Yes, in the case of asking to provide proof that the animal is trained, but he's not allowed to charge him a fee because technically it's not a pet.
You got it partially right. It's no on both counts. You cannot require proof that the animal's trained. What's to stop you from training the animal? And if it's an emotional support animal, they don't need any training. Just merely them being there to comfort and soothe you, to sit on a lap and let you pet them is enough. Okay. Now, what about if you wanted a cat or ferret instead? Well, the answer is no. As landlord didn't handle the request correct, landlord cannot charge John a pet deposit for his animal because it's not a pet, but rather a service or companion animal required for his disability. Further, the landlord cannot ask for proof the animal's trained. And lastly, companion and assistance animals do not have to be just dogs. They could also be other animals like cats and ferrets and birds. And I wrote here, beware of fake service animal registration websites that may look legit. Now, this is old. This is from like 2016 or something. But check out this newscast here.
The largest airline to crack.
This is why they did away with requiring both service and emotional support animals to be allowed on planes in public accommodations.
Down on the so-called emotional support animals since that song. The policy change was prompted in part by a passenger who tried to board a United flight with a large peacock on Sunday. Delta announced similar restrictions just last month. CBS News travel editor Peter Greenberg is at United's hub at Newark Liberty International Airport, and that's where that peacock was grounded. Peter, good morning. Most people don't think of peacocks as emotional support animals.
No, but they are. In fact, more and more airlines are reporting that the number as well as the types of emotional support animals is reaching crisis proportions. Now, we're not just talking, as you can imagine, dogs and cats. In fact, the interior cabins of some flights are beginning to resemble Noah's Ark.
I'm not kidding. This woman is wrangling her peacock into the airport.
United Airlines says it warned the peacock's owner 3 times that Dexter would not be allowed to board. The bird lives with an artist in Brooklyn who claimed Dexter was her emotional support animal. In this 2016 interview, she described how she found him.
I got him originally for an art project, and but then this happened, and I was like, do I have a peacock currently in my neck? Yeah. Yes, I do.
United Airlines already prohibits non-household birds, hedgehogs, ferrets, spiders, sugar gliders, and other exotic animals. Its new policy requires owners to give 48 hours advance notice when flying with a support animal, provide a letter from a mental health professional, and documents from a veterinarian showing the animal is vaccinated and not a threat to the public.
We've had roosters and ducks and pigs and monkeys.
Sarah Nelson is the president of the Association of Flight Attendants and says she applauds the new policy changes.
But what we really need is for the Department of Transportation to act with guidelines for the entire industry.
United saw a 75% spike in comfort animals, from 43,000 in 2016 to 76,000 last year. The critters sometimes relieve themselves in damaged planes. In June, an emotional support dog bit a Delta passenger. Can pigs fly? In 2015, we showed how easy it was to get one on a flight. A Colorado counseling center provided CBS This Morning with a letter prescribing the pig as the primary treatment for a psychological disability. Tom Panic, CEO of Guiding Eyes to the Blind, says people are passing off their untrained pets as service animals.
As a person who is blind, my access rights are being infringed upon when somebody passes off a fake service dog.
Now, the new policies for United and Delta kick in on March 1st, and American Airlines is expected to follow suit. But we should note that the new policies only apply to emotional support animals, not the trained, specially dedicated animals that fly for and with people with disabilities. John?
Peter, thanks.
Yeah, people take their pets very seriously. We get it. But you see a lot of people taking advantage of that policy. So I think it's good that they're trying to figure out a way to crack down and make sure that the legit animals go.
And they did by no longer allowing emotional support animals on planes or public accommodations. They have to allow only the trained service animals.
The largest.
So here you go. Here's a list of between service animals and those emotional support animals. Service animals have to be allowed in public access, air travel, housing. they're trained, but they don't need proof that there's training, because what's to stop them from training themselves? I know most people don't know how to train their own dog not to pee in the house, but let alone alert you to the a seizure coming on or your blood sugar running low. There's no registration or certifications for service or emotional support animals either. Now the training here, I got you a little note, means that they're trained to perform a specific task beyond service and basic socialization and obedience training. Emotional support animals are no longer allowed, granted by law, and a requirement that they have to be allowed in public access or air travel. They are still required to be allowed in housing to live with their owner. No requirement for training or being registered or certified. And then we have a fair housing poster, and it is the end of the day, so we'll pick up at fair housing posters here tomorrow. And we got to pick up the pace because, I don't know, somehow we're falling behind you. We usually do, and I don't know why. I think it's all these videos I put in here. I guess the explanations I give for the additional tips I give you and resources too. Sometimes explaining that stuff makes us fall behind a little bit. So we're going to have to play a little catch up. Let me stop